Ever feel like being a plan sponsor is all responsibility and no glory? Well, buckle up, because the Supreme Court just handed you one more thing to worry about, and you can't drop the ball on this one. In Cunningham v. Cornell University, the U.S. Supreme Court issued a unanimous ruling, yes, 9-0, that makes it harder for plan sponsors and fiduciaries to get retirement lawsuits dismissed early. Here's the key takeaway. When participants allege a fiduciary breach under ERISA, courts can't just dismiss the case because there might be a reasonable explanation for the fiduciary's actions. Instead, if the allegations are plausible, the case can move forward, and you, the plan sponsor, may be required to prove your actions were prudent. That's a major shift. The burden of proof no longer rests entirely on the participants. It can now fall squarely on the shoulders of fiduciaries. In plain English, just thinking you acted in the best interest of participants isn't enough. Now you have to show that you followed a documented and thoughtful process, considered alternatives, acted solely in the interest of planned participants. If you can't back up your decisions with clear documentation, you could be exposed in court. So what should plan sponsors do now? Number one, document everything. The target date fund change you made. Why did you do it? Who was in the room? What data did you review? If it's not in writing, it didn't happen. Number two, review fees and providers regularly. Don't wait 5 years to benchmark. You should have a documented cadence for fee benchmarking, RFPs, and share class reviews. And when you do it, write it down. Number three, understand the why behind every decision. It's not enough to say, we went with what our advisor recommended. That won't cut it. Know the rationale, discuss the alternatives, and document the deliberation. Keep minutes. They matter. Your committee meeting minutes shouldn't sound like a coffee chat. They should read like a defense strategy, because someday they might be. And train your committee. You don't want a deer in the headlight look every time someone asks a committee member what their fiduciary duties are. Regular fiduciary training is your friend. And finally, lean on your experts. You don't have to do this alone. Consultants who specialize in retirement plan governance, like our team at Strategic Retirement Partners, are built for this. We know how to do the heavy lifting, build a defensible process, and help you stay ahead of evolving fiduciary expectations. Our job is to protect you, your people, and your plan. The message from the court is clear. Fiduciary responsibility isn't just about good intentions, it's about good documentation, and the burden is now on you to prove it. If you've been coasting on old decisions or hoping no one looks too closely, it's time to tighten up. Because when the lawsuit comes, and they do come, you want to be the plan sponsor who says, here is our process, let's go. That's it for this week. This is Jeannie, the 401k lady.